Welcome to SCOTUScast, a project of the Federalist Society for Law and Public Policy Studies. Our contributors join us from around the country to bring you expert commentary on U.S. Supreme Court cases as they are argued and decisions are issued. The Federalist Society takes no position on particular legal or public policy issues. All expressions of opinion are those of the speaker.
Hello and welcome to SCOTUScast. I'm your host, Justin Drower, on behalf of the Faculty Division of the Federalist Society. We're here today to discuss Moore v. Harper, which was argued before the court on December 7th, 2022. It's my honor to introduce our guest today, Andrew Grossman, a partner at Baker and Hostetler, where he co-leads the firm's appellate and major motions team. He's also an adjunct scholar at the Cato Institute's Robert A. Levy Center for Constitutional Studies. And with that, I will hand things over to Andrew.
Today, our topic is the argument in Moore versus Harper. It went on for, nearly 3 hours. And I think it provided a lot of clarity for a case that has been one of the most high-profile cases of this term, but also one of the most misunderstood. My plan for today is to briefly discuss the case's background, go over some of the topics that were discussed at argument, give a little bit of analysis, perhaps some thoughts on the way the court is looking at the issues in this case, and then conclude with, it's always fraught to do it, but some predictions as to which way or ways the court might go. Beginning with the background of the case concerns the power of a state legislature when it is exercising its authority under the federal Constitution's Elections Clause. The Elections Clause gives a state legislature the power to prescribe the times, places, and manner of holding congressional elections. What happened in this case was that the state legislature enacted a new congressional district map for North Carolina following the 2020 census. Plaintiffs brought suit contending that the map was a partisan gerrymander in violation of the state's constitution. And the North Carolina Supreme Court agreed. And so the issue was presented, do provisions of the state constitution constrain the legislature's authority when it is prescribing regulations pursuant to the Elections Clause? Now, specifically, there were three provisions of the North Carolina Constitution that the North Carolina Supreme Court held rendered the map, prohibited partisan gerrymandering of certain types and cited as its basis for striking down the legislature's map. One was a provision that all elections shall be free. The second was that the people shall have the right to assemble together to consult for their common good. And the third was a provision protecting the freedom of speech. The court also adverted to another provision that is akin to the federal Constitution's Equal Protection Clause. From those provisions, the court derived a principle of political equality. And from that, it put forward the holding that a congressional map must not diminish or dilute on the basis of partisan affiliation. In other words, political parties must have substantially equal opportunity to translate votes into seats. On that basis, it struck down the legislature's map. As the case comes to the Supreme Court, the central issue is whether that ruling, that is the application of state constitutional provisions to the legislature's map in this instance, contravenes the Article 1's Elections Clause. The petitioners in this case put forward two theories. The first, which is broader, is the view simply that because the Elections Clause specifically delegates this power to the legislature of each state, a state cannot constrain the legislature's exercise of that power through provisions of its constitution. In other words, when a legislature is acting pursuant to this grant of authority, it is not subject to or limited by provisions of the state constitution. Their fallback theory, which is somewhat narrower, is simply the point that drawing maps and assessing claims of partisan gerrymandering inherently involve questions of political judgment. And by deciding those types of questions for itself, particularly based on vague and open-ended provisions of a state constitution, the state Supreme Court effectively put itself in the legislative role and exercised legislative power as referred to by the Elections Clause. As for the respondents, their view, I think, is severalfold. First, just that the term legislature has always been understood to encompass a legislature that is bound by ordinary provisions, that is ordinarily subject to judicial review, including judicial review for compliance with state law, including state constitutions. Their view also is based on history and the claim that for many years, perhaps as far back as the founding, I suppose I should say it's the framing of the Constitution, states have simply assumed that provisions of their constitutions did apply to state legislatures' promulgation of regulations pursuant to the Elections Clause. They also argue that the Supreme Court's precedents endorse that view. There's a lot more that could be said about the background of the case, but I think that's enough to set up the disagreement between the parties. There were a number of topics that arose, and I think it's fair to start off by saying that the argument was somewhat inconclusive. This wasn't a case where it is apparent exactly what it is the court is going to do or how it's going to approach the questions presented by this case. But I think we can identify several of the leading topics of discussion that interested the justices and drove the argument. The first is the question, what is the source of law here that's relevant to the question that the court is reviewing? In fact, that was Justice Thomas's very first question, and one that was repeated at various points by different of the justices to various of the advocates. Now, why is that a significant question? It's a significant question because, as the petitioners have framed the issue, the Elections Clause is a delegation of federal lawmaking authority to state legislatures. And so it naturally follows that if we're talking about a source of law that is federal in nature, it would not be preempted by state constitutional provisions. Instead, it would be subject to federal constitutional law only, as well as subject to preemption by Congress acting pursuant to its authority under the Elections Clause. So that's what makes this a significant question. And it's one that, as I said, Justice Thomas pressed, but it was also raised at various points by Justice Alito and Justice Gorsuch as well. A second topic that was addressed in many questions relates to the text as well as the history of the Elections Clause. Of course, as for the text, the fundamental dispute is what the word legislature means and whether if that means narrowly a state's lawmaking apparatus, typically colloquially referred to as a legislature, whether that therefore implies a limitation that legislature is not subject to substantive state constitutional provisions. There were, of course, each side, has its favored history to cite. On the petitioner side, they're happy to cite statements by James Madison, as well as Justice Story's participation in Massachusetts politics, as well as his famous constitutional treatise. On the respondent side, they put great weight on state constitutional provisions that regulated elections in various ways, and according to them, also reached federal elections subject to the Elections Clause. They also put some weight on events that occurred in other states, some historical court decisions, as well as several court decisions dating as far back as I believe the 1870s, in which state courts struck down legislative congressional district maps. I think it's fair to say that there was no consensus one way or the other based on the history of the application of the Elections Clause. It's certainly not an issue that the court has ever decided directly, and the different historical materials do point in different directions. I will say, however, that I thought the respondents did score some points and seemed to seem to illuminate several of the justices when they pointed out simply how many states at this point in time do have constitutional provisions that are being applied and have been applied in recent years to regulate elections within states, including federal elections. So I think that's something where the respondents, did have a point, and the petitioner's response to that point was simply that this more recent practice is not probative of the original meaning of the Elections Clause. For that, you have to look back further in history, and the history at that point shows a paucity of decisions striking down state legislative enactments for violation of state constitutional provisions. A third topic, and one that consumed, one that was raised in a great many questions, involved the various decisions cited by the respondents as supporting their view, and indeed, as they said in some instances, basically deciding this case. I identified four cases that were really three cases, I guess I should say, that were raised repeatedly, particularly by the respondents. The leading one, of course, is the Supreme Court's decision in Smiley, where it held that a legislature's exercise of its Elections Clause power is subject to a gubernatorial veto if a state constitution does prescribe that. The petitioner's response to this point is simply that is a procedural rule, and that the U.S. Constitution takes legislatures as it finds them. They're, of course, established by state constitutions. And so the way that a state legislature enacts law is considered to be part of the legislature for purposes of the Elections Clause. And so that would include a gubernatorial veto, which was, of course, well known at the time of the framing, and was, according to several historical dictionaries, considered to be part of the legislature. As I believe it was Justice Gorsuch pointed out, there is a reason, for example, that the president's veto power is identified in Article 1 of the U.S. Constitution, which generally concerns the legislature, as opposed to Article 2. The second case was the court's relatively recent decision in Rucho versus Common Cause. That was the case where the court, in an opinion by the Chief Justice, held that partisan gerrymandering claims simply are not justiciable in federal courts as a matter under federal law. And the court's basis for that decision is that questions of gerrymandering really do involve inherently questions of political judgment. And they're simply not susceptible to judicially discoverable and manageable standards. It's just not the kind of thing that a court can decide while it is acting as a court and exercising judicial power. The court did, however, in Rucho, leave open the possibility that these sorts of claims could be addressed by state constitutions and by state courts. And so that, of course, is something that the respondents in this case have seized on as indicating that states do, in fact, have the power to control state legislatures through constitutional amendments, including constitutional amendments that may prohibit gerrymandering. The third case cited in support of the respondent's position was the Arizona state case from several years ago. This was another case that involved the Elections Clause. And the question there was whether a referendum that created a nonpartisan redistricting commission was an appropriate exercise or was, I guess, consistent with the Elections Clause, or whether that was a usurpation of the state legislature's power under the Elections Clause. Surprisingly enough, the case was not subject of deep discussion and oral argument, despite being a football in the parties' briefs. Of course, the respondents argue that by authorizing a referendum process, which is akin to the processes that are used frequently to adopt state constitutional amendments, that the Arizona state case very nearly decides this case. And indeed, Arizona does contain some broader language expressing the view that state legislatures are, at least in some instances, constrained by state constitutions. On the other hand, the petitioners point out that the substance of the power that the redistricting commission was exercising in that case was actually not part of that case. What was really at issue was the propriety of the referendum itself, and the court's decision doesn't extend beyond that. Whichever way the court looks at it, for whatever reason, the parties, even including the respondents, did not place great emphasis on the Arizona state case. The fourth case I'll mention, and this was brought up more by the petitioners, was the court's Palm Beach County case. This was a case that was a forerunner of Bush versus Gore, and in this decision, the Supreme Court vacated a decision of the Florida Supreme Court for the reason that the Florida Supreme Court's for the reason that it was unclear to what extent the Florida Supreme Court was premising its decision on interpretation of state law versus the application of the provisions of the state constitution. And that decision, which is under the electors clause, which is similar to the elections clause in assigning power to the legislature of a state, that decision did quote language from a case called McPherson versus Blacker that opined that it would be improper for a state to constrain a legislature's exercise of authority through constitutional provisions. And so the idea of Palm Beach is that the court recognized the vitality of that principle and that limiting factor. I think while Palm Beach was mentioned a number of times, there was, particularly by the petitioner, there was some pushback, including by Justice Kavanaugh, that the decision simply doesn't extend that far, that it was largely a procedural decision, that it was unanimous in that its language and reasoning are somewhat more ambiguous and somewhat lacking. The next topic I'll mention was a strange new respect for Chief Justice Rehnquist's concurrence in Bush versus Gore. In Bush versus Gore, there was an argument. The court ultimately decided the case on equal protection grounds. But Chief Justice Rehnquist wrote a famous concurrence in which he pressed an alternative ground of decision. And that was simply that the state Supreme Court, the Florida Supreme Court, had significantly departed from the legislative scheme for appointing presidential elections. And on that basis, its decision violated the electors clause, which, as I noted, assigns power to the legislature. Surprisingly, all three of the advocates arguing against the state legislature in this case all seem to endorse various versions of Chief Justice Rehnquist's reasoning in his Bush versus Gore concurrence. In other words, they acknowledge that there are limits to what state courts can do when they are adjudicating laws enacted pursuant to the elections clause, and that does present a question of federal law. We'll get back to that, but I think it is interesting that it was only several years ago that concurrence was being described regularly in the academic papers, as well as in the media, as being radical and aggressive. But it seemed to, in this case, be universally accepted as a correct statement of the law. Finally, many of the court's questions involved issues regarding line drawing. In other words, whichever rule the court addresses, there are potential difficulties in terms of how it would define that rule and how subsequent courts would actually apply that rule going forward in deciding cases under the elections clause. For the petitioner's theory, the petitioner acknowledges that state legislatures can be constrained by state constitutions' procedural provisions. In other words, for example, a presentment clause that requires a piece of legislation to be presented to the governor, who then may sign it or veto it. But the petitioners distinguish between those types of procedural provisions and substantive restrictions. For example, limitations on gerrymandering, or a substantive limitation that voting has to be conducted in a particular way. Their view is that those types of state constitutional provisions cannot constrain a state legislature acting under the Elections Clause. Justice Sotomayor, in particular, was forceful in pointing out that courts have, for many years, have had difficulty in distinguishing between substantive and procedural rules when you're talking about federal regulations and review under the Administrative Procedure Act, and likewise have had difficulty in distinguishing between substantive and procedural rules of decision and rules and laws that apply in court when you're talking about the Federal Rules Enabling Act and to what extent different provisions of state law are applicable in federal court or not. And I think a number of questions recognize that this may present a difficulty for the petitioner's central theory. Of course, the petitioner's response was that this is the type of distinction that courts draw all the time. And that in this instance, the mine run of provisions are pretty clearly fall on one side of the line or the other. In other words, as a practical matter, it really isn't that hard. The second concerned the argument that was pressed, particularly by respondents, that the proper standard is when a state really gets, and I'm just going to say, a state court gets off the reservation. And there were any different number of ways that the Respondents' Council, as well as the Solicitor General, any number of different ways that they expressed this particular standard. But the idea is that when a state court departs too far from a state law and from a state constitution, what is the right standard there? Is it, as Chief Justice Rehnquist said, a significant departure from state law? Is that the right way of formulating the standard? Or is that, not to use the phrase that was battered around a fair amount, sky high enough? In other words, is it not sufficiently deferential? And if that is the right approach generally, putting aside how exactly you define the standard, does the same standard apply when you're talking about state laws versus state constitutional provisions? One Respondents' Council said, yes, there is a distinction and the courts ought to be more deferential to state constitutions. The other Respondents' Council said, no, he didn't perceive a difference between the two. So that is a question if the court, where that line lies and whether there's one line or two lines. But that's a question the court would have to address if it does go down that road. A final line drawing question concerned the respondents' position for their interpretation of the force of the word legislature. They've argued in their briefs that that even under their view, there must be a central role for the legislature. And as the petitioners pointed out, that's a very vague way of putting it. What does that mean? How is that adjudicated? What's the rule of decision? As Petitioners' Council put it, the respondents appear to adopt a sort of functional test. In other words, look at what is actually being done. But of course, functional tests of that sort are notoriously difficult to apply in practice. For that reason, the petitioner argues that their more formalistic test regarding substantive versus procedural constitutional limitations is a much easier one to apply. But I think the point stands that whichever way the court goes, however it interprets the Elections Clause, there may be some line drawing questions, and the court may be forced to try to put pen to paper and flesh out a workable standard. So I'd like to give a few points of analysis, sort of my takeaways from the decision. And the one I'm going to start with doesn't really go to the merits of the case, but I think it really does drive a lot of the public interest in this case. And this is the dog that didn't bark. For months and months and months, we've been hearing a parade of horribles we've been hearing stories about a parade of horribles that would follow if the court were to rule for the legislature in this case. For example, that the legislature could steal an election after election day and take the votes away from the voters, that state legislatures could wholesale disenfranchise groups of voters, engage in invidious voting discrimination, that somehow our whole democracy would be placed at risk. I think it's significant that of the three advocates who argued against the state legislature's position in this case, not one made any of those claims. There was no claim that a decision for the state legislature would allow the stealing of elections. There was no claim that it would result in disenfranchisement, and there was no claim that it would somehow override the broad protections of voting law, the broad protections of federal law that generally serve to prevent disenfranchisement and that ensure equal voting rights for all Americans. So much of the public reporting on this case has really been over the top and filled with really a lot of very strong invective. I don't want to argue, and I don't believe that this is not an important case. It is an important case because it asks the question of whether federal election rules will be decided by democratically elected legislatures versus, in some cases, state courts wielding open-ended and vague provisions of state law. And that is a very important question. But as to whether our democracy hangs in the balance and legislatures might steal elections, that simply isn't what this case is about. And I think anybody listening to today's oral argument would recognize that those simply aren't the stakes by the people who actually, according to the people who actually know what this case is about. Second, what do the justices think of the legislature's primary theory? In other words, this categorical rule that a state legislature can never be constrained by substantive provisions of a state constitution. Well, I think we know where probably at least five of the justices stand on this. I've made maybe even six, let's say. Among the commonly identified as liberal justices, I think it's very clear that Justice Sotomayor and Justice Jackson simply reject every argument that the petitioners pressed in this case, and that their view is that the primary theory is simply wrong. Justice Kagan did seem to reject the primary theory of the petitioners, but she did seem a little bit more open in her questioning to narrower ways of looking at the case, and we'll get to that. On the other side, Justices Alito and Gorsuch were very full-throated in their view that the petitioner's view of the Elections Clause is basically correct as a textual matter and as a pragmatic matter in terms of how it would play out and how it would work and how it's been understood through history. And I think the same can be inferred by Justice Thomas's questioning as well, particularly his repeated questions on the source of the law underlying the question in this case. Justices, the Chief Justice, as well as Justice Kavanaugh and Barrett, seemed a little bit less clear about what they thought about this theory, and it did ask questions of the advocates on both sides. I think there still is a pathway by which the petitioner in this case does prevail on their primary broader theory. And it really relates to a question that Justice Gorsuch asked of one of the respondents' counsel. The question was, if you concede, as the respondents' counsel did, as did the Solicitor General, that state court decisions are reviewable to see if a state court went too far in some way in applying and adjudicating or striking down, as the case may be, a state law regulating federal elections, where does that come from? In other words, what is the source of that limit? Because if you're talking only about state law, well, then there are only state law questions, and the federal courts do not answer generally state law questions. And certainly the Supreme Court would not be answering state law questions in this context. If it comes from the word legislature in the Elections Clause, if that is the limit, then doesn't that seem to give away the whole case? Because if the limit is that legislature means legislature, and therefore there is something to review to see if the state courts went too far away from what the legislature did or acted in a way that's inconsistent with the legislature, well, that concedes an awful lot, and it would seem to at least implicate the central theory of the petitioners in this case. And so it may be that the logic of Justice Gorsuch's question on this point, in other words, if you're willing to accept any limitation, isn't that the whole ballgame? It may be that as the court ponders these issues and works out the implications of the various arguments that were put forward, that it recognizes that that concession is enough for the court to decide the case. Third, I think there was, however, even more interest, perhaps, in a narrower approach to deciding the case, including the fallback theory that was put forward by petitioners. I think it's fair to say that the Chief Justice, Justice Kavanaugh, and Justice Barrett all asked many questions about narrower approaches to deciding this case. And they all seem to be searching for some way of deciding this without necessarily having to embrace, in this case, the categorical rule that was put forward by petitioners. And so they asked a lot about Chief Justice Rehnquist's concurrence in Bush versus Gore and how that might apply, how the principles from that concurrence might apply under the different theories, as well as some of the outer reaches of what state courts might do in ruling on election clause legislation and how it is that federal courts might deal with that. They all seem to be grasping for some type of narrower approach, and it's possible that the approach that they settle on may be some version of the fallback theory that the petitioners put forward, their backup argument. And I'll get to that a little bit. I'll flesh that out a little bit more in a moment when I turn to really my final analytical point, which is, as I mentioned, there was this strange new respect for Chief Justice Rehnquist's Bush versus Gore concurrence. In fact, I think there may have been more discussion and more questions on that concurrence than any other topic in this case. And to this observer, at least, that came as somewhat of a surprise. The reason that was a surprise is that the petitioner in this case does not raise an argument that the state Supreme Court significantly departed from state law in deciding this case. In other words, the petitioners here raise their categorical argument, they raise their fallback argument, but they don't raise an argument that the North Carolina Supreme Court got North Carolina law wrong so egregiously that it was a significant departure from state law and thereby implicates federal interests in federal law in the way described in Chief Justice Rehnquist's concurrence. That said, there are other ways that that Chief Rehnquist's logic may factor into this case, and I think it's worth teasing those out. The first, and it's very simple, is just the idea that yes, this case and the state laws that are at issue, the state redistricting plan, does present a federal question. So that's very basic. And to be honest, I think the questions of the justices went far beyond that. A second way of looking at it is simply as an alternative limitation. In other words, if there has to be some kind of limitation, the one that Chief Justice Rehnquist put forward is one that, by all appearances, all the parties could live with. Now, of course, the petitioners would like additional limitations. But everybody on both sides did endorse in some fashion the rule that Chief Justice Rehnquist put forward in his concurrence. And potentially that could be something for the court to gesture towards if it were to rule against the petitioners in this case. In other words, the court could say that this is the proper limit, but it isn't implicated by this case because the petitioners didn't raise this kind of argument. Now, third, and I think this is perhaps the most likely, is that looked at it from a certain angle, Chief Justice Rehnquist's logic does provide support for the petitioner's fallback argument. Let me explain how. Chief Justice Rehnquist identified the legislature as the central actor in making elections regulations. And he rejected the view that a state court could usurp that role through reinterpretation of state law or through other machinations. Now, if you take that, you can combine that principle with Rucho, which recognized that questions of partisan gerrymandering involve inherently political judgments of the sort that aren't intrinsically judicial. In other words, it's legislating, even if it's something someone is asking a court to do. And that's particularly so when you're talking about vague and open-ended provisions of a constitution that don't provide judicially discoverable and manageable standards for the court to arrive at a rule and then tell the court how to apply that rule to a given congressional map. In other words, what is the rule of decision? Instead, a court has to decide how much representation is right, how to measure that, how that should be balanced against other considerations, and so forth. And so if you combine the logic of Chief Justice Rehnquist's concurrence with the logic of Rucho, what you get is a rule that suggests that in a case like this one, a state court has gone too far if it relies on vague and uncertain constitutional provisions to override a legislature or to devise its own map or its own standards for partisan gerrymandering. Because to do so is to essentially exercise legislative power. And maybe the rule would be different when you're talking about specific state constitutional provisions that provide a rule of decision. Maybe the rule would be different if the state itself had proposed a rule, if state law itself had proposed a rule of decision. But in a case like this one, where a state Supreme Court is discovering the standards from vague provisions of a state constitution, it simply is taking for itself the role of the legislature in a way that contravenes Chief Rehnquist's view of the Electors Clause, and by extension, the Elections Clause, as well as Rucho's understanding of what it means for what renders an act sort of inherently political and legislative in its nature. So some guesses, I'll conclude with some prognostication about the different ways the court might decide the case. And of course, I want to start by saying predictions are hard, particularly predictions about the future. And in this case, particularly, it's very difficult, I think, to have a firm view of what the court can do, because there were really so many different avenues that were discussed both in the briefs as well as at oral argument. I think there is, as I said, still a pathway open for the petitioner's primary argument. That said, there is perhaps a greater likelihood that the court may seize on the petitioner's fallback argument. And if it does so, it could even leave that broader argument, the categorical approach, it may leave that for a later case and a later day. Because if the court decides this on narrower grounds, then of course it wouldn't need to decide the broader issue of whether state legislatures are categorically free of state constitutional provisions when they're exercising their power pursuant to the Elections Clause. A curveball, and it has less to do with this court than with another one, is that the North Carolina Supreme Court, may well reconsider this decision in the time that it is being taken under advisement by the U.S. Supreme Court. New justices have recently been elected to the North Carolina Supreme Court. As I understand it, and I'm no expert on North Carolina Supreme Courts, the balance on that court has shifted. And there is certainly a possibility that as a result, recent decisions of the North Carolina Supreme Court under its outgoing majority may be called into question, potentially even in the near future. If that happens, it is certainly possible that the U.S. Supreme Court may not even wind up deciding Moore versus Harper.
Thank you for listening to this episode of SCOTUScast. SCOTUScast is a project of the Federalist Society, a not-for-profit educational organization of conservative and libertarian law students, law professors, and lawyers, founded upon the principles that the state exists to preserve freedom, that the separation of governmental powers is central to our Constitution, and that it is emphatically the province and duty of the judiciary to say what the law is, not what it should be. Don't forget to subscribe to our podcast series, including SCOTUScast and Practice Group podcasts, on iTunes or Google Play. For an archive of past podcasts, as well as audio and video of past Federalist Society events, please visit our website at fedsoc.org/multimedia. That's fedsoc.org/multimedia.
This has been a FedSoc audio production.